Thank you very much, Chairperson. Yes, I'm one of the youngest in terms of application, but may say that I'm not the youngest in terms of experience. And why do I say so? I have a short, brief history. I was born in a family of almost 25 children, a polygamous family. I am the firstborn, and I became their leader when I was very young, taking care of them. Thereafter, I would want to give out my story. I was born and brought up in Nakuru. Later, I went to a primary school called Menengai Primary School in Rongai, Nakuru. I proceeded to Kipchirchir Girls, then to Solian Girls, then to the University of Nairobi. Chairman, the issue of being young was manifested in me, that is leadership in me, when I was waiting to join the university in 1989. I was called to start a secondary school called Kirobon Secondary School, and I started it from the scratch. At that particular time, Chairman, I was only 21 years old, and I was the headmistress of that school. From there, Chairperson, I joined UON to pursue LLB. That was in 1989 up to 1992. And while at the university, I was made a class representative and also representative to the Senate. Issues of disciplinary issues affecting students, I was in charge at that particular time when I was in Parklands campus. Still, I was very young.
Councillor, are you referring to any material? Because we prefer that you just talk to us without referring to any written notes.
Oh,
thank you.
Thank you, Chair. I think I'm used to writing. That's a problem with advocates in court. From the University of Nairobi, Chairperson, I joined, we had a short stint outside. We couldn't join Kenya School of Law on time. We joined Kenya, we finished in 1992 and joined Kenya School of Law towards the end of 1994. It was a problem of the double intake. While I was in that limbo, I joined Kenya Industrial Estates, where I became the legal officer with attendant duties of drafting documentations, advising investors and all that. Then thereafter, Kenya School of Law, wherein I completed in 1995. After completion, I got married, moved to Eldoret, and set up a family. I am a mother of 2 children, grown-ups. Unfortunately, I lost my husband in 2012, but life has moved on. In Eldoret, I opened up Yano and Company Advocates. That was towards the end of 1996. And that is the law firm I still run up to date. Despite other engagements I've been getting from side to side, the main engagement that I've been running from 1996 to date is Yano and Company Advocate. While in Eldoret, we formed a group. We called ourselves the Few At Least Enlightened Women. We formed a group of about 6 ladies, and we said, what is it that we can give to the society? And the most important thing that we did is we came up with an NGO called RWIBIS, Rural Women Empowerment in Basic Services. And what did he do with this group? We realized that in the village, and especially Elgeyo Marakwet, our people were not very well economically endowed. And the majority of the affected were women and children. So that the moving factor was we had more of the mud hut houses, the grass thatched houses, and we made it a point to encourage our women to come together, to fundraise amongst themselves, and go towards ensuring that each and every family had a mabati house. And we were able to do so many. We would put the women together, we would encourage them, and then would link them with other NGOs for purposes of being funded. And that is a project that I'm still very proud of. And it is something that made me know that teamwork, you can be able to do a lot.
As counsel,
yes,
practicing in these courts, have you faced? And which you think the judiciary ought to rectify?
Well, thank you very much, AG. Yes, as a practitioner, yes?
Say three.
Three. As a practitioner in the courts, the problem that really was really the issue that really made our practice difficult is the disappearance of files. Sometimes you come to court, you're ready, then from nowhere your file cannot be seen.
That's to do with the expeditious disposal of cases. If the file is missing, it delays your filing of whatever application you wish to make. It delays, etc.
Yes.
Apart from that line of challenges, are there any others that you have experienced as a consumer of the services of the judiciary?
Oh yes, there is the usual times you appear before a magistrate or a judge, and the treatment you get is not very comforting. You feel there's some bit of, it could be a disconnect between you and the judicial officer, the magistrate, and you feel you are not really, it's like you're not welcomed in that particular court. You know, what it does to the confidence of that advocate. You feel you even presenting yourself could be very, very difficult.
Thank you. That's one. Another?
From the experience also is, I don't know now whether the infrastructure in Milimani has improved, because sometimes back we even wrote a letter. It was to do with the ramps. Small things to put, because we were saying kindly put for us the Mabate.
So there are problems to do with the infrastructure in the judiciary. That's two. Thank you.
Infrastructure. And the other thing really is perception. But we've learned to live with it. When somebody files a case, and within a short while they're getting this and everything is hard, it's like, could you have been there to bribe the magistrate, or could you have given out something, that kind of thing. So it also makes you feel, there's some suspicion surrounding, which is wrong.
All right, those three. Please address us on each as to how you, as Chief Justice, would offer remedial measures.
For the attitude, really, for me, it's something that we build some sense of understanding and knowing the kind of environment. All of us are officers of the court, the kind of environment we work in. We can be able, maybe once in a while, put these people together. We don't have to have, throughout we have maybe CLE for advocates only, we have JLE for judges only or magistrates. Personally, I feel there should be a way we can mix in a way that we get to, not really in terms of seminars or workshops and all that. We can create something and put maybe practicing advocates and the judges and magistrates together. It will clear that discussion, that openness. As for infrastructure, I think it's something that, to me, I'm not quite sure. If it has been put, then that is good. That is a matter of ensuring that proper how to access courts, simple things like hygiene can be, it is something that can be corrected very easily.
Learned Counsel, you've been practicing these courts all over the country for the last 25 years. You must have some idea of what our courts are in terms of, to use your words, hygiene, for instance. You're now Chief Justice. You have the opportunity to rectify whatever you have seen that is not good. How would you go about it?
Of course, working through the administration structure, ensure that probably reasonable toilet facilities are there. Water actually, I think, Commissioner, you're aware, Milimani, we've had issues of water for a long time. And those are things that can be addressed. I don't think it's a matter that cannot be addressed. And then the issue of bribery, it cuts across. And it's not only the advocate or the judicial officer. How can we deal with that? To me, vibrant communication is key.
Can we be a little more specific, Learned Counsel? Use a wider word of corruption. What are your perceptions about corruption in the judiciary?
Yes, for me, corruption in the judiciary really tangible evidence that corruption, I've seen corruption in the judiciary, I'll be lying if I said that. But there's that perception. That perception, because how can Mr. X today come to court and he gets a hearing date, maybe for May, June, and here Ms. P comes to court and given a date next year. So those are things that, makes the party things. Could there have been something that had been done? How could have this judgment be delivered within such a short notice as against judgments that have been lying with a magistrate or a judge for a long time?
Yes.
Yes.
So, yes, those are the manifestations of that perception.
Exactly. So you see, it is through some of these omissions that parties get a bit jittery that there could be some corruption somewhere. A file disappears for ages. What is happening? Or at times a file maybe is awaiting, let's say judgment has been given or rulings have been given, and those files are not released immediately to the registry. So those are the perceptions.
And these perceptions, Learned Counsel, have led the public to lack confidence in the judiciary.
It's true.
And this is now yourself as the Chief Justice. What steps, what measures are you going to take to restore that public confidence, to remove these perceptions, to make the general public believe that the judiciary is not corrupt?
First and foremost is communication. There is so much that the judiciary has done that is good, but you see, to be shrouded with that or veiled with that veil of corruption, really let it go out that the judiciary is not as corrupt.
How would you do that communication?
Communication, you can do the annual communication. I see there's a structure to do annual communication, though that is not enough. Can a website be created for the public to be knowing what is happening? Is it like using Service Way? Can it be communicated to the public what the judiciary is doing? The other issue is to work on the backlog, because that is where also this perception comes from. How comes this matter has taken so long? Is it because there is somebody who's been seen to sit on the file? Actually, the term they use is to sit on the file. But then you find maybe the judiciary may not have that empowerment to process the cases as fast as they would wish. Like the case example I gave of the, what has made backlog of judiciary to be seen as not working.
Yes.
Lack of enough judicial officers. We've talked about the 40 judges. My easy step will be this. Directly opposite me sits the Attorney General of this good country of ours. I'll start caucusing with the Attorney General. First and foremost, I start from here. He is the chief legal advisor to the government. We sit down with the members of this commission. First of all, let us evaluate as members. What is the problem? When did the rain beat us? Let us first of all focus from here, discuss, exhaust, and come up with a way forward. And for me, if we can be able to do that, come up with a way forward, then if the next way forward is to go and see or meet with the appointing authority, then it would have come. It is an initiative of Judicial Service Commission. So would be there with the Attorney General, and it will be upon maybe the Judicial Service Commission to say maybe the Chief Justice, Bwana AG, another two, move together, go and see the appointing body and ask him, kindly let us have this country move. Swear for us these 40 judges. That way, we can be able to use that link properly, because that link is there. It's only that the link, of course, may not be misused, may not be seen to be misused by eroding the independence of the judiciary. And when Kenyans see 2 or 3 people moving together, then even that connotation of the judiciary is being compromised may not arise. And sometimes I feel like joking. If we have a lady CJ, like for me, I think I just pick a phone call and call Mama Margaret, kindly call me for a cup of tea and get me to know the moods of Mzee. Can he get to hear us? And then I come and talk to my members of the commission. We move and go and meet Mzee for purposes of having this. That's a joke, by the way, my lord.